So I want to welcome everyone to today's presentation. It is an honor to introduce our speaker today. My name is Seth Zirkle, attorney with Condes Donovan Kahn in Evansville, Indiana. On behalf of the Evansville Lawyers Chapter, I'd like to welcome all of our participants. Today is auspicious for a couple of reasons. One, we've got a great speaker that's going to offer some very timely cogent observations that are pointed for a number of reasons. Two, it's an opportunity for us to hear from an individual at a leading academic institution. Many times, we hear from other practitioners who are to some degree removed from the milieu, as it were. Professor Kleinfeld's on the ground, in the trenches, as they say. So without further ado, I'm going to go ahead and give an introduction to our speaker. As our typical practice, I will then turn the floor over to our speaker. Upon the conclusion of his remarks, we'll then open it up for question and answers. Given the number of participants and the fact that we are all collegial participants, I would ask you to, if you have a question, to unmute, to ask the question, and then to please remute the mic to allow Professor Kleinfeld to then answer. So very happy today to introduce Professor Kleinfeld as our speaker. He is the professor of law and, by courtesy, professor of philosophy at Northwestern University. Prior to that, he was a visiting professor of law at Harvard and also at Stanford. His education, he has a degree of PhD in philosophy from the Goethe Institute University, at Frankfurt, where his dissertation was on embodied ethical life and criminal law. His law degree is from Yale Law School, which he received in 2006, and his undergraduate degree in philosophy he received in 2001. His selective practice and policy experience, as you can imagine, is extensive. He's, since 2001, been involved, an integral part of Northwestern's Supreme Court Clinic, and prior to that, he was involved with the university's Juvenile Criminal Defense Clinic. He clerked with Harvey Wilkinson on the Court of Appeals of the Fourth Circuit from 2007 to 2008, as well as with Janice Rogers Brown, the DC Circuit, 2006 to 2007, as well as the Honorable Aaron Barak on the Supreme Court of Israel, Summer Court clerk in 2004. His writing is extensive and it's varied, and I would urge you all to take some time to visit the university's website and to look at some of his recent ethics decision topics. Beyond today's topic, of particular importance to me is his involvement in the President's Council on Bioethics as a senior research analyst from 2002 to 2003. Without further ado, I'll go ahead and turn the floor over to Professor Kleinfeld. Thank you so much, sir.
Thanks, Seth, and thanks, folks, for coming. I see Stephen Vaden in the attendees. Hi, Stephen. We're old friends. It's great to see you here. I'm grateful to Seth for inviting me. I talk with a lot of professors and students, as you can imagine, and it's always a privilege for me to get to talk with lawyers in practice and judges as well. So thanks for being here. And I'm going to try to present relatively briefly so we have plenty of time for questions and discussion. So there's a lot of talk today about the problem of cancellations in law schools, generally uncivil behavior, political aggression in law schools. All of those things are problems, to be sure, but they're also, what I'm here to say, is that they're just the tip of a very, very big iceberg. And I'm here to tell you about the rest of the iceberg. Sometimes I think of, if there is a submerged mountain, what do the fish see and what do the surface dwellers see? Well, what the surface dwellers see is a piece of rock or ice jutting up from the surface of the water. Mostly they see water, but they do see this rock formation or ice formation. What the fish see is a huge mountain. And when it comes to universities, I'm one of the fish. And I thought it would be interesting to tell you about what it looks like to me. And I'm trying to advance a thesis here. The thesis is that something momentous is happening and indeed has happened in our time. The momentous change is not the result of one sort of grand policy change. Rather, it's the sedimentary accumulation of a lot of individually small changes that collectively add up. There's a great line in Hegel's Logic where he says, if you pluck enough hairs off a man's head, eventually he's bald. The line is about how changes in degree can eventually become changes in kind. That's what I think has happened in law schools in America and in universities more generally. That a qualitative change has emerged from a series of small individual policy adjustments. So what's the change? What's the momentous change I'm trying to describe? Here's how I would characterize it. In paradigm one, in law school, when most of you went to law school, indeed when I went to law schools were left-leaning, to be sure, but also committed to open inquiry based on argument and evidence. And there was sometimes a tension between those two aspects of law schools. It was unofficially clear that most faculty and students were liberal, Democrat, progressives. But as a matter of official institutional stance, law schools didn't have an ideology in a conventional sense, maybe loosely some sort of rule of law commitment, but not a political ideology in an activist sense. We are now in paradigm two. We are now at the other side of a qualitative change. In this new era, law schools are committed to an ideology which is really the official ideology of the institution, not just an ideology shared by most of its members, but an ideology of the institution itself. And accepting that ideology becomes the price of admission to the governing political class. It becomes the price of admission to being socially and academically and indeed professionally acceptable in law school and as a lawyer. And that ideology is enforced by an increasingly formal structure of sanctions. And so the institutional project of the law school isn't just sort of transmitting a body of knowledge and a set of craft-related skills that are the skills of a lawyer with no particular ideological commitment except ones that exist informally in the background. Rather, the institutional project becomes training and sifting members of the legal class for ideological acceptability in the American elite. So these are big claims. I'm claiming that there has been a profound and, to my mind, distressing and alarming change in America's law schools, that we've seen radical change in our time. I want to tell two anecdotes that I think are illuminating to this effect and talk about, I'll sort of unpack the anecdotes. I'll talk about the general patterns that I think they demonstrate. And then, not claiming to have fully substantiated my big claim about a paradigm shift, I'll open it up for questions and discussion. I think fully substantiating the big claim would be the work of a book. So here's the first anecdote. A few years ago, I had a student in my class, my law school class, who had arrived in college from a family of modest means, and he was the first in his family to go to college. It was the beginning of his freshman year. He was 18 years old, and he was naive. He found himself in a class discussing why women and men often go into different career fields. And he foolishly, naively, honestly raised his hand and suggested that there might be natural or genetic differences between men and women leading them to different career fields. Well, it won't surprise anyone who has been observing American politics in the last 20 or 30 years in academic culture that the other students took offense. Of course they took offense. That won't surprise anyone. Here's what might surprise you. It didn't end with the other students in class being offended. Rather, the students organized over social media to track my students' movements around campus. Using social media, wherever he was, the other students in the university or in the college would ping each other with his location, and they'd go and mock him and denounce him wherever he was. So there would be communication around the college. The bigot is in the cafe, the bigot is in the cafeteria, the bigot is in the gym, and then students would go there to sort of denounce and mock him wherever he found himself. And that went on for about a semester, 4 months of steady tracking. I'd like to unpack this anecdote. The first thing that I'd like to communicate is that if this anecdote shocks you, I would like to respectfully suggest that you have underestimated how extreme the atmosphere in universities has become. If you were well informed, you would not be shocked. The anecdote is a little unusual, a little extreme, but by no means radical or shocking relative to the norms of law schools and universities today. That is to say, my first general point, what is happening in law schools and universities is extreme. And so beware of anchoring, beware of assuming that law schools today are basically like law schools when you went to them. They might be superficially similar, but under the surface quite different. And behavior that sort of takes your breath away because you are anchoring to your own experience is entirely normal now. So the anecdote I've just told is entirely normal. Second point I'd like to make in unpacking this anecdote is that it demonstrates the culture of aggression and even cruelty that now prevails among many students, not all, but many. At every major law school and at every university, there are a group of students fully prepared to harm in the name of ideology. There's a burgeoning literature about the woke movement. It typically focuses on the substance of woke ideology. What I want to suggest is that maybe the substance of the ideology doesn't matter as much as the simple willingness to harm others for the sake of your ideology, whatever it is. There have been examples of this sort of behavior at other times in global history. Think about Marxism in early 20th century Russia, or jihadist Islam in early 21st century Saudi Arabia, or inquisitorial Catholicism in 15th century Spain. What binds them all together isn't the substance of the ideology. The substance of the ideology changes. What binds them all together is the willingness to harm in the name of ideology. How should we define cruelty? I define cruelty as the desire to harm someone or something with a face. Students, a great many students today, by no means all, are willing to look another person in the face and do them harm intentionally, deliberately, for the sake of a political ideology. Ideologies come and go, but the creation of a group of people ready to do harm in their name is important in political history. I mean, as my examples illustrate, they become historical events. When you animate young people in early 20th century Russia with Marxist ideology, or jihadist Islam in 21st century Saudi Arabia, and inquisitorial Catholicism in 15th century Spain, when you create a group of people who are ready to harm in the name of their ideology, it can affect all of political history. On that note, I'd like to present a question for your private reflections. How often have you set out to harm another person? Not as a side effect of some duty, like you have to hire someone and those who are not hired are inevitably disappointed. I mean an act of voluntary effort to harm, where you've, for example, tried to get someone fired from their job, but they're not at your workplace. You don't work with them. You're not responsible for them being hired or fired. You've just reached out to another workplace to try to get them fired. How often have you tried to make someone friendless? How often have you tried to shatter another person's happiness or well-being and relished in the shattering of them? I'm going to venture a guess. For many of you, the answer is never. I've never done that. And for others of you, the answer is, well, once, middle school, twice. It's hard to get normal people to deliberately inflict harm. The psychology of deliberately inflicting harm is not a normal one for human beings, and it takes a lot of in-group, out-group pressure and motivation to get normal people to deliberately inflict harm on others. So it's quite remarkable that there is reliably a group of students at virtually every campus that are inclined to do harm in this way. It doesn't take much of that kind of active, malicious harm doing to radically change a university culture, or indeed any institutional culture. Just think about a typical 18-year-old who doesn't want to have a horrible, scarring, traumatic experience of college. They will see my former student being followed, tracked around campus for having the temerity to raise his hand in class and suggest that there are genetic differences between men and women that affects their career choice. They will see how he was treated and right away learn which ideas are allowed and which are not. I think about my oldest daughter, who is 12 now. And like a lot of 12-year-olds, like a normal 12-year-old, she's incredibly oriented to what will bring her social esteem with her peers. She will immediately absorb the range of acceptable and unacceptable opinions and reflect them because it's more important to her than any other. The desire for esteem will outweigh every other desire in her heart. And I think that's just normal, and especially normal for people who want to be liked, who are vulnerable to one another. To some extent, that's all of us, but maybe it's especially us when we're 18 or 19 years old and in college. Third point in unpacking this anecdote, I want to point out the role of technology in aiding and abetting this student culture of aggression. Sometimes I think people exaggerate the role of technology. It has become increasingly common to argue that cancel culture, or indeed the whole woke movement, has something essential to do with social media. I think that's quite mistaken. The underlying phenomenon of ideology and aggression is not based on technology. It exists in times and places where it's not technologically mediated. Again, think of my examples, 15th century Spain or 20th century Russia, or 21st century Saudi Arabia. Furthermore, the woke movement itself and cancel culture predates social media. What we now call the woke movement and cancel culture was in the 1990s labeled identity politics and political correctness. It was the same ideology and the same behavior. There were a ton of cancellations in academic institutions in the 1990s based on saying things that were considered unacceptable with respect to race and gender and other protected groups. And of course, all of that predates the internet explosion, social media explosion we've seen in the 2000s. Indeed, the great response to what was then called identity politics and political correctness was penned by Alan Bloom, his famous book, Closing of the American Mind. Closing of the American Mind was published in 1987. The movement was already well underway enough that his book could become a runaway bestseller for responding to it. So that said, having said that technology is not the instigating force in the woke movement or in cancel culture, it does matter. And it shows up in the anecdote about my students. Technology doesn't create this movement, but it allows coordination, surveillance, memory, and anonymity. Coordination, the different students work together to ostracize him, denounce him, and track him. Surveillance. What they were doing was keeping track of him, so he couldn't escape. He couldn't say, okay, I'm now unpopular with this group of students. I'm unpopular in this dining hall. I'll go to this other. There was no escaping because of the tracking. And I see this with other students as well. They get tracked. They try to publish a law article and they said something in law school 5 years before was considered unacceptable. And there's a coordinated effort to track them. So it's known that they're trying to publish a law review article, and the student editors of various journals get notified that their article should be rejected because of what they said some years before. As I said, this stuff is increasingly common. Memory. What happens with a lot of our embarrassing comments from our past is they simply fade, right? As life goes on and people go on with their lives. There's a limited number of people who heard the embarrassing thing we said some Tuesday morning in 1994, and they don't keep bringing it up or they forget about it. Life moves on. But technology makes it very easy to reference things from the past and bring them up again and again and again. And finally, anonymity. When a person aggresses against another person and attacks them, of course, there's counterattack under ordinary circumstances, but technology makes it possible to pursue an aggressive path without anyone knowing about it. So this is coming up with jobs. I mentioned that it comes up with law review articles. People try to publish and others sort of find out about the submission and try to get it canned. It also happens with jobs. So people apply. It's increasingly common when my students apply for law firms for other students to send anonymous reports to the firm, which then withdraws the hire based on the student being controversial. And of course, it doesn't have to happen all that often for other students to be afraid of it. All right, so much for anecdote number 1 and my 3 points about it. Let me move on now to anecdote number 2. Anecdote 1 was mainly about student culture. What we're seeing is a student movement, and student movements can be very powerful in culture. Anecdote 2 is more about institutional factors. It's about the changing face of law schools and universities on an institutional level. A few years ago, a law professor I'm friends with retired. My friend is a pretty left-wing guy. He would define himself by his lifelong commitments to civil rights and socialism, and he certainly thinks of himself as a man of the left. He was a little young for retirement, and I asked him why he was retiring. And he told me about how a group of students in his class were upset with him for saying things that weren't in line with woke ideology. The students were more than upset. They brought a complaint against him in his university's Office of Equity, stating that he had said racist things in class, and he was investigated by the Office of Equity. It's called an investigation, by the way. The Office of Equity opens a file on a professor and proceeds to engage in an Office of Equity investigation of the allegations of wrongdoing, which are, of course, are anonymous. It happened that my friend had recordings of the class sessions in question and could prove that he never said those things. They were just factually false. They were allegations of specific statements on specific days. He could play the recordings of those days. He had never said those things. He had never said anything like those things. It was just lies. The investigators in the Office of Equity didn't then say, "We're so sorry you've been through this ordeal on the basis of lies." They just pivoted. They said, "What did you do in the course of this class to make your students feel that you had said something like that? What did you do to make them feel that you had said something like that?" At that point, my friend turned to the law school administrators for support. And of course, the law school administrator said, "We are not permitted to intervene in Office of Equity investigations." And they just wanted nothing to do with it. And they washed their hands of it. Now, my friend was not fired. He was tenured. And at the end of the day, the allegations were false. But he was encouraged to retire and offered a financial package to retire. And he took the package. He just didn't want to be part of the university. So I'd like to now unpack this anecdote. The first thing to point out is the power of the Office of Equity at virtually every major university around the country. Depending on when you went to law school, offices of equity might not have existed at the time, or might have existed but not have been very important. They are now among the most active and powerful offices at any university. The officers of the Office of Equity are not administrative assistants. They are powerful university officials. At some universities around the country, as civil servants working for the state, their salaries have to be disclosed. You can look up the salaries of the major figures in the Office of Equity at UCLA or Berkeley or University of Michigan or University of Virginia, the public universities, just like you can with anyone working there. They are earning hundreds of thousands of dollars, sometimes as much as $300,000 or $400,000. So they are very, very important officials, and they're paid accordingly. They are also armed with substantial powers. They are armed with investigative and enforcement powers. And their enforcement powers are very real. It gets a little unclear whether they can cut a tenured professor's salary. Typically, that's protected by tenure, but there's typically bonus portions that are not protected by tenure. And there are various other consequences that can be imposed on a professor outside of purely financial or purely compensatory things affecting research budget, teaching, and the like, which are under the power of the Office of Equity. So they have real powers. There are also a lot of them. They're very well staffed. A typical university might have 10, 20, 30, 40 officials associated with the Office of Equity. They have a huge caseload. So we're lawyers. We know how to describe something of the kind I've just described. We're essentially talking about an administrative agency, right? If this was a federal agency, we describe it as an administrative agency. They do agency litigation, right? So there are allegations of wrongdoing and internal courts within the agency for processing those claims. And they have powerful officials with real powers and substantial discretion in how they exercise those powers. What we're talking about is an internal administrative agency in virtually every university processing agency litigation. And the result, at least at some universities, it varies by university, is that equity complaints are a normal part of university life. Students routinely file them against one another. Students file them quite regularly against professors. Professors file them too. They file them against one another, and they file them against students every once in a while, and they file them against administrators with some frequency. And of course, the staff files complaints against the various other actors in the university. It's part of the culture. This is where, remember what I said about how you might think law schools and universities are kind of similar to what you experienced when you were in them, but they're not. We now have a university environment where complaints by members of the university against one another for various sorts of diversity-related offenses, you could call them woke offenses, speech offenses, are investigated formally. The complaint triggers a mandatory investigation. The complainant is insulated from retaliation, which makes it, of course, often strategic to file. There's typically no dismissal procedure for frivolous complaints, and no sanctions for frivolous complaints. So there's no 12b6, there's no Rule 11. There's just tons and tons of formal institutional complaints and what amounts to an enforcement apparatus for the woke ideology. So recall what I said about how the woke ideology has become the ideology of the institution. Well, this is part of how it's become the ideology of the institution. A major internal administrative agency has been developed for enforcement purposes. I know of one major university in which there were just so many complaints that the Office of Equity couldn't handle the quantity, and the university started to outsource it to a local labor law firm. So the local labor law firm was essentially on retainer of the university and mainly handling student says, a 19-year-old student says, this other student said something racist to me. This professor made me feel discriminated against as a woman. This professor gave me a bad grade on the basis of my being of X group. This other student, et cetera, et cetera, et cetera. Just a constant litany of complaints that are being investigated by a local labor law firm, except the labor law firm couldn't handle the quantity and started to outsource it to another labor law firm. And now in the city, the volume is so great that it's a big university, but the volume is so great that the Office of Equity and a whole series, the Office of Equity is essentially like managing. It can't straight the complaints itself. It's managing a set of law firms that are on retainer to investigate them. It amounts to a formal enforcement structure for the diversity ideology. And so we've shifted from an old paradigm in which there was peer pressure to conform to an ideology to a new paradigm where this is not peer pressure, not merely peer pressure, this is institutional power. It's made teaching a lot less fun. Professors are afraid of their students, including very left professors. And it's led to a kind of defensive teaching, similar to defensive medicine, to set in, where faculty ask out of courses they've taught for years or teach in ways primarily designed to control risk. A number of professors I know have switched to a pure lecture format, a very scripted discussion, not because they're uncomfortable with the ordinary give and take of law school discussion or Socratic dialogue, but because they're doing risk control, they're doing risk management. Lots of professors insist on recording all of their classes, and some law schools now insist on that as a matter of policy. And it leads to extensive virtue signaling in class. So you might be teaching a sort of conventional doctrinal class in a conventional doctrinal subject. Maybe you're teaching civil procedure and you're talking about federal preemption, something like that. What the professors will do is have lots and lots of hypos that reflect the prevailing ideology. The good guy in the hypo is always discriminated against, member of a special group. And the bad guy is some straight white male discriminating against that person. And it's transparent to all involved, the students and the professor, that what's going on is a kind of virtue signaling, which is showing what the acceptable opinions are and showing the students that the professor has acceptable opinions so that the professor isn't then accused of wrongdoing some time ago. By the way, this increased unpleasantness in teaching has affected the number of aspiring law professors. Aspiring law professors tend to be pretty well qualified and they have other options. Traditionally, a lot of good students wanted to be law professors. When I went on the market in 2010 and 11, the number of aspiring law professors who filed the form saying I'm in the pool of candidates this year was about 1,500 to 2,000. It has fallen to about 300 to 400. Did I say 15,000? I meant 1,500 to 2,000. So it's fallen from approximately 2,000 to approximately 300. That's the scale. Not 15,000, but still quite substantial. And finally, I want to point out the role of the administration in this new world order. When some person gets controversial, maybe a professor who is an internal person, maybe an external person like a guest speaker, the administrative script has gotten pretty consistent. The cardinal rule is never to be outflanked to the left, but it is still the case that most universities do not want to be seen as against freedom of speech. And so often what you see is a public statement in support of freedom of speech, but also a public statement denouncing the content of the controversial speaker's speech. That is to say, the university will say in a public statement, the law school will say in a public statement, while we support this anti-abortion Catholic speaker's right to their opinion, and while we support their freedom to express it, we denounce the misogynistic, anti-woman content of their speech. So what you have there is the law school not representing itself as substantively neutral. The law school has an ideology which is expressed. Meanwhile, if the speaker is a guest or is untenured, they are typically just fired. And if they are tenured, like my friend, they are sort of sidelined or quietly ushered out. So let me end now with a reflection, big philosophical reflection. I'm half philosopher. I hope you'll permit me a large-scale philosophical reflection. I think we tend to underestimate the possibility of radical change in our own time. Partly it's an anchoring effect. You ask someone about college and they inevitably think back to their own time in college, and it's hard to imagine that it could be that different. It's especially hard to imagine that it could be utterly different and look roughly the same. I mean, you think back to your own time in college, you were 18 to 21, you were going to class, choosing a major, playing a sport. You look at people now, they're 18 to 21, they're going to class, choosing majors and playing sports. How different could it be? Well, it can be just as different as a family filled with love versus a loveless family that's just going through the motions. That is to say, it could be utterly different and superficially similar in ways that are not obvious to an outsider. And I want to suggest one more philosophical thought in this regard. I think part of the reason we underestimate the possibility of radical change in our own time is because of a deeply rooted but altogether false assumption. Let me present a distinction between two ways of relating to time: individual time and societal time. Individual time is the development of an individual human being over time, over the course of a life. Societal time is the development of society over time. Our usual assumption is that individual time is fairly fast. There can be a lot of change fairly rapidly. You go from an adolescent to a young adult, to someone with a career, to having a family, to an empty nester, and it all happens relatively quickly. And we assume that societal time is slow, like a big aircraft carrier versus a little speedboat. The huge aircraft carrier surely changes direction slowly. Things unfold slowly over the course of societal time. I think that assumption is exactly wrong, and in fact, backwards. Once adulthood is reached, an individual life is often fairly stable, 30, 40 years being roughly the same person. Meanwhile, societies can utterly transform. Think about the progress of technology. 40 years takes us back to the era in which families had one phone attached to the wall in the kitchen with a rotating dial. And now every pocket has a cell phone that functions not just as a phone, but as the gateway to a whole digital life. Or think about music. 40 years takes us back to the era of, or almost back to the era of doo-wop and jazz, where Miles Davis was a cultural icon. Takes us through the era of rock to the era of disco and the era of hip hop. It's counterintuitive, but societies actually change faster than individual lives, precisely because they're big, precisely because they're collective, precisely because they're not anchored to any one individual's personality or course of life or way of looking at the world. Societal time isn't slower than individual time, it's actually faster. And so the thrust of my presentation today is that even if you went to law school just 20 years ago, let's say, there can be, and there has been truly radical qualitative change in America's law schools in that time, even where things look pretty similar, even in our own lifetime, there has been radical change to such an extent that your own point of reference, your own experience of law school just a few years or decades ago might be more misleading than it is illuminating. I'll end there. Thank you. Seth, Jana, you want to take over with questions to the extent there are some? Seth, you're frozen there.
Sure. Thank you so much to open up. There we go. Sorry about that. Happy to open up the floor to anyone who would like to ask a question. I'd ask that Professor Kleinfeld can then provide an answer.
Maybe use the hand function. Jana, is it possible for me to see the participants? I see Steve. I don't know Michael, Ryan, and the other Steve, Stephen Theising, but imagine we could just make it a roundtable at this point. There we are.
Yeah, I'm going to give them all permission to talk, so they should be able to speak now.
Josh, this is Stephen.
Hey, friend.
How are you doing?
I miss you, buddy. I'm good.
Well, part of you is with me. As you know, I've got one of your students clerking for me currently.
I know. It's great.
She's off to a good start. So I've got a question for you, Josh. You've identified several anecdotes that illustrate the problem. What ultimately is the solution? We've seen what happened at Stanford, where a sitting federal judge was accosted not just by students, but by a member of the administration itself. And then that member of the administration was chastised by the dean in a relatively well-received 10-page memorandum in which she sent them all to re-education camp to learn about the First Amendment. do you think that strong stand in other schools adopting the University of Chicago free speech principles will begin to form defensive lines that can be held? Or do you think those in the woke community will continue to storm the gates and push things further and further back? What do you see as the next act in this play?
I think that let me speak for a moment about Stanford and try and draw some general lessons. I think that punishing the administrators, chastising them, firing them, or moving them out of their position and into some different position will have some marginal effect. I think adopting the Chicago principles, it will have quite minimal effect. I am puzzled at the feeling among many of my colleagues who share my distress at the present cultural moment, thinking that if the university adopts these paper principles, it will really change things. I mean, we haven't formally adopted those principles in Northwestern, but we have a very strong official rules in favor of free speech, and it doesn't change a culture of ideological totalitarianism among the students or among much of the faculty and administration. I think those are what Carl Llewellyn called paper rules, a very minimal effect. And I think the most significant thing about Stanford is that the students are completely unpunished and indeed kind of flourish in their in the sort of moral honor that they get from this kind of aggression, precisely because it was aggression to a federal judge, precisely because to the members of their own tribe, they showed courage in accosting a federal judge. So no, I don't think those things are at all adequate or lead to any lasting change, with the small marginal exception of a mild rebuke of a staff member. And by the way, that mild rebuke doesn't amount to like eliminating the position or something like that. The power of these offices of equity is undimmed. So what do I think would make a difference? I think at public universities, the deciding who gets to be a student there should not be a university function. Why do we assume that universities should get to choose their own students to the extent they're public universities? Is that supposed to be some sort of piece of academic freedom? It's not a piece of academic freedom, never has been. Rather, these universities are discharging a public function. And what they're doing is essentially selecting for radical students. They look at the personal essays. I mean, if any of you have advised students on their personal essays, you know the game. You're supposed to signal your loyalty to these various ideological movements. And to the extent, you do charitable activities through your church, you're excluded from admission. And to the extent you do charitable activities by leading a BLM march, you're included in the institution. You're brought in, as well as the very, very extensive and sometimes illegal ways of taking into account race and other identity characteristics that's performed by the admissions officers. I think the right of ingress, of deciding which students get to come to the university, if it's a public university, should be a public function that's taken on board by a branch of the legislature, a branch of the governor's office fairly directly. And likewise, deciding who can no longer be part of the institution, that is, the major issues of suspension and expulsion, should also be a publicly discharged function. I think that and that kind of action is the scale of and creativity of thinking we need to address the problem. I should give you a chance to respond, Stephen.
Well, I don't want to take up the entire time. I'm certain other people have questions, but I'm curious what you think of. There are two schools of thought that respond to these things. It seems to me like your position is a middle position that I haven't heard before. I haven't thought about delegating the function of admission and discipline to a non-university or at least non-university controlled body. That's interesting. Usually there are a group of people who say, look, we need to stand on our principles in responding to these people who are challenging the basic premises that have underlain academic freedom and the First Amendment going back to almost the founding of the country. and we can't adopt their tactics to fight their tactics. So I'll declare those people as kind of the Puritans or the angels or however you wish to. And then there's another school of thought that says, look, if this is the way it's going to work, that, you know, when federal judges and other people with whom certain elements of the left disagree, if they can be called out, chastised, canceled, whatever verb you want to use, well, so can you. And something tells me that I bet many federal judges would find it interesting to know if a future lawyer arguing in front of them were one of these people who thought that one of the appropriate ways to express their views was to shout down a fellow federal judge. So maybe we should get all of these people's names who participated in this protest at Stanford. And for example, if they get hired by a prominent firm, which is easy to determine because they always put their pictures up on the website, let some of those firms' clients know, hey, did you know you're paying $700 an hour for somebody who thought yelling at a federal judge was appropriate to represent you in a federal court? How do you feel about that? And let the chips fall where it may until both sides realize that this is a game neither side really can win if we both keep playing mutually assured destruction until it quits. I'm curious what you think of those two proposals. Keeping in mind, it sounded like you had a middle ground.
Yeah, I don't think of it as a middle ground. Let me first say, I understand the polarity that you're presenting. I've seen both sides. In general, I'm more on the latter than the former. But I don't think of it as sort of like, well, if they're going to be unprincipled, we should be unprincipled too. I do think unilateral disarmament is unwise. For me, you can tell I'm struggling a little bit to formulate the position here. I think the present woke movement is an opportunity for us to think more carefully about what our principles are and should be. So when a law student tries to cancel speakers, shows by their behavior that they have no commitment to freedom of speech, or even says, as many do, right, that freedom of speech is a wolf whistle for racism and discrimination, and they're against it. They think Americans' freedom of speech is just a cover for a white supremacist country. I think that should be remembered. I would not be inclined to respond by trying to get them fired from their firm, telling their firm and telling their firm's clients, look who you have hired. I would say they should be ineligible for a federal judgeship or any sort of judgeship or any sort of prosecutor position, anything working where they take an oath to uphold the Constitution. Not because it's just a revenge tactic, but because they've shown themselves to be opposed to fundamental constitutional principles. And I think a list of the Stanford or Yale or other students who have behaved in that way and taken that kind of position, and indeed the administrators and the professors who have supported them in taking that kind of position, should be compiled and maintained for purposes of functional exclusion from federal office. Now, there are limits to that. If a president decides, if there's an activist student who is openly opposed to freedom of speech and the First Amendment and calling it cover for white supremacy, and a Democratic president wants to appoint that person for the judgeship, and a Democratic Democratic Senate wants to consent to it, so be it. That's the constitutional order. But I do think it's entirely appropriate to take that kind of thing into account in deciding about the distribution of offices where it's your oath to uphold the United States Constitution. So I don't think of that as just sort of fight fire with fire. I think of that as just like, oh, their behavior prompts me to see that, as law students at an elite university, they're the kind of people who might get federal office or state office, and they take an oath to uphold the Constitution, and they're behaving inconsistently with that oath and showing that they can't in all integrity take that oath. Or by the same token, seeing how these universities are functioning prompts me, at least, to thinking, why do we assume that universities get to pick their own students? For that matter, why do we assume that they get to pick their own professors? The judiciary doesn't get to pick judges. Rather, the president, the politically accountable Democratic branches pick judges. Do judges have tenure? Yeah, I mean, federal judges have tenure just like professors have tenure, more so. They're independent upon assumption of the office, but they're not picked internally. They're picked externally. So you see, Stephen, how when you start to think about principles in a new way in light of current realities, you don't have to be unprincipled to be fairly, let's say, active about fighting this current movement. That's my thought.
I think I'll just close by saying your analogy to how the judiciary is picked and the different roles people play. I think you need to develop a talk, Josh, on empowering particularly public university boards of trustees to understand that they actually run the university, because that's what I thought of as you were talking. Sounds to me like you might could buck up people like the trustees of the University of North Carolina.
Well, and incidentally, in Israel, it was the assumption that what judicial independence means is judges get to pick judges. And it was essentially the Chief Justice, the man I work for, Aaron Barak, who picked every member of the Israeli judiciary from the lowest level, magistrate judge to the highest level members of the Supreme Court. He did so as part of a committee, but the committee was dominated by people he had already picked. So functionally, it was just the judiciary picking its own members with quite minimal participation from the prime minister, the Knesset. And when that was challenged, the Israeli judiciary said, well, this is just a judicial independence. You must be fascist. You must be against the rule of law for doing exactly what we do in this country constitutionally in saying judges are fully protected from being fired or having their salary diminished after they assume office. But the picking of them is a public function for the democratic branches. Why don't we think the same way about university professors? Why can't we say, well, the picking of them is not a purely internal procedure, even if they're protected thereafter, and it doesn't impinge on academic freedom or academic independence to have that structure any more than it impinges on judicial freedom and judicial independence to have the structure laid out in the US Constitution. So again, Stephen, I'm not saying fight fire with fire. I'm saying think harder about what our principles ought to be. Maybe with that, I better go to Michael. Hi, Michael.
Thank you, Professor. I was wondering if you had read your colleague, Professor Koppelman's opinion piece in the Chronicle about what he thought of the Stanford protests.
You know, Andy's my best friend on this faculty. We're very close. And I feel a little bit aggrieved that he didn't tell me about this piece. I'll have to reach out to him and see what he said. I haven't seen it yet. And normally I don't have to look in the Chronicle. Andy and I send each other anything that we've written.
Well, it was his argument. I mean, he basically called the protesters infantile but said, his main persuasive argument was that they won't be good LGBTQ rights lawyers if they continue to act like this, that they need to listen to the other side. They need to listen to arguments and learn how to rebut them properly and logically and legally than to just yell and scream and shout people down.
That's Andy's take on these things. That would be a persuasive way to encourage people to stop doing this. That's Andy's take on these things. Andy is himself a left liberal guy. He wrote the amicus brief that was the basis for Neil Gorsuch's opinion in Bostock after a whole career of fighting for LGBT rights. Andy's first published article when he was his law review note was about how the right of abortion is constitutionally protected, not on the basis of privacy, but on the basis of the 13th Amendment, because to deny women the right to get abortions is to enslave them. So he is not exactly a conservative, to say the least, but he truly believes in the liberal ideal, I mean, the traditional liberal ideal in the classical liberal sense, that ideas need to be tested by argument, that you'll be a better advocate for your idea if you truly listen to the other side and respond on the basis of reason. And I have to say, I admire the hell out of Andy for believing that, and I admire the hell out of those who agree with him and are members of the left, but still fight for commitment to reason, freedom of speech, intellectual diversity, and the like. However, if you or he or anyone thinks that encouraging that attitude is a sufficient response to the present cultural moment, that is a benighted view. It will not begin to make a dent in anything. It is true, but being true is insufficient to make a real difference in today's politics. And simply encouraging that attitude, it's not like all those students who are denouncing people, or professors who are denouncing people, or staffers who are creating DEI offices just say, oh my gosh, I should have listened to the other side, I'll be a better lawyer. No, none of that will ever happen. I encourage utmost cynicism about the prospects of this very true argument actually accomplishing meaningful change in today's politics or universities. Say one more thing. I wonder if Andy and others of his school of thought, people who just truly believe in the value of the interchange of ideas to make everyone's arguments better, I wonder if they underestimate how much political power is to be had by suppression and political cruelty and aggression. You know, movements that are premised on totalitarian thought control do prevail for long periods of time. They might not prevail forever, they fall, right? But Marxism in the Soviet Union had a 100-year run, or an 80-year run. Inquisitorial Catholicism in 15th century Spain had a 100-year run. In other words, it might be that excluding those who disagree, silencing those who disagree, and creating environments in which everyone preaches the party line or holds their tongue and no one learns to respond to the other side is a pretty effective way of maintaining political power. But Michael, I should give you a chance to respond. I've been pretty cynical about this, notwithstanding my admiration for the view. What do you think?
Unfortunately, I think I might agree with you. So,
okay.
And I represent several universities and think the best of the local ones here. I think Purdue does a good job with teaching First Amendment principles to incoming students, but I think the elite universities may have lost the battle.
Yeah. And I think what happens when they lose the battle is people like my 18-year-old student, come to college, or he was 18 at the time, naive 18-year-old, say the wrong thing, get scarred and traumatized by sort of utmost ostracism. Everyone else gets the message. I don't know how many of them nurse doubts in their heart of hearts, but I imagine it's a little bit like nursing atheist doubts in medieval Europe. It doesn't prevent an ideology from prevailing for a very long period of time. If those doubts ever, eventually overthrow the world order, it can take centuries.
Well, given our time, I would like to thank Professor Kleinfeld once again for presenting today. Very engaging, very informative, and very timely. I want to thank all of our participants for listening in, and for those that raised questions, thank you very much for that. For those who are able to join us, I would like to let everyone know that we will be having a program on May the 10th with Tim Carney from the American Enterprise Institute on his recent book, Alienating America, Why Some Places Thrive While Others Do Not. And I will be sending out information for that event. Professor, thanks again for your time today, And with that, we are concluded.